Imagine auditors ignoring massive fraud signals, signing misleading financial statements, violating independence rules, and helping management conceal governance failures, while investors continue trusting the company blindly until the entire corporate structure collapses publicly. Then regulators begin investigations, shareholders lose crores, directors face litigation, and one terrifying legal question emerges. Who will be punished for violating the audit provisions under company law? That is precisely where Section 147 of the Companies Act 2013 becomes one of the most powerful enforcement provisions in the entire audit governance framework. Welcome to Corporate and Securities Law Compass, navigating law with clarity. Today, we are discussing one of the most feared and practically significant provisions under the Companies Act 2013, Section 147, dealing with punishment for contravention of provisions relating to auditors. This provision transforms audit governance from theoretical compliance into enforceable legal accountability. Without Section 147, the entire audit framework under Sections 139 to 146 would become weak and ineffective. Appointment rules would exist without consequences. Independence provisions would lack enforcement. Fraud reporting duties would become symbolic. Audit governance would collapse into formality. Section 147 therefore acts as the enforcement backbone of corporate audit regulation. To understand this provision properly, we must first understand one foundational governance principle. Corporate law does not merely create rights and obligations, it also creates consequences. Without penalties, governance standards often become meaningless. Audit functions directly affect investors, creditors, regulators, lenders, employees, and market confidence. Therefore, violations involving auditors can create enormous public harm. Section 147 exists to impose accountability where audit responsibilities are breached. Historically, several corporate scandals globally exposed catastrophic consequences of weak audit accountability. Auditors overlooked fraud, failed to verify records properly, ignored internal control weaknesses, maintained prohibited relationships, suppressed qualifications, or failed to report irregularities. These failures caused investor losses running into billions. The Companies Act 2013 therefore strengthened penalty provisions significantly. Section 147 reflects this governance philosophy of strict professional accountability. Now let us understand the statutory framework carefully. Section 147 provides punishment for contravention of auditor-related provisions under the Companies Act. Immediately, several important concepts emerge. Contravention, professional misconduct, fraud, penalty, imprisonment, liability, compensation, refund, governance enforcement. These concepts collectively create the legal accountability framework governing auditors and companies. Now let us discuss the legislative intent deeply. The law seeks to ensure that auditors perform statutory duties seriously and independently. Audit reports influence public investment decisions. Therefore, negligent or fraudulent conduct by auditors cannot remain lightly treated. Section 147 therefore emphasizes deterrence, accountability, and investor protection. Now let us discuss applicability carefully. This provision applies where auditors contravene provisions relating to appointment, independence, prohibited services, reporting obligations, and related audit governance requirements. It also extends consequences to companies and officers in default in certain situations. Now let us discuss practical governance significance. Audit failures rarely affect only internal management. They impact public trust. Investors rely on audited financial statements. Banks rely on audited numbers before lending. Regulators rely on audit assurance. Therefore, audit violations create systemic governance risk. Section 147 recognizes this broader economic impact. Now, let us discuss penalties conceptually. The law provides monetary penalties and, in serious fraudulent situations, potential imprisonment consequences. This is extremely important. Audit misconduct is not treated as mere procedural irregularity. Serious violations may attract severe professional and legal consequences. Now, let us discuss one of the most important aspects: liability for fraud. Where auditors knowingly or willfully participate in fraud or collusion, consequences become significantly more severe. This transformed professional accountability standards dramatically under the Companies Act 2013. Now think practically. Suppose auditors intentionally ignore fake invoices, fabricated revenues, or manipulated inventory records despite clear warning signs. Such conduct may no longer be viewed merely as professional negligence. It may trigger serious fraud-related exposure. This is the governance power of Section 147. Now let us discuss refund and damages related implications. Auditors involved in misconduct may face liability relating to audit fees and damages arising from incorrect or misleading statements. This strengthens financial accountability. Now let us discuss practical governance chronology where violations emerge. Audit irregularities identified. Regulatory scrutiny initiated. Financial records examined. Professional conduct evaluated. Audit working papers reviewed. Contravention determined. Penalty proceedings initiated. Professional disciplinary action considered. Civil and criminal exposure assessed. This entire process can become extremely serious. Now let us discuss connection with Section 143 because this is critically important. Section 143 defines auditor duties and fraud reporting obligations. Failure to comply with those duties may attract Section 147 consequences. Both provisions operate together. Now let us discuss connection with Section 144, where auditors provide prohibited services compromising independence. Section 147 may become relevant through enforcement consequences. Thus, independence and penalty frameworks are interconnected. Now let us discuss practical governance risks. Fake clean audit reports. Suppression of qualifications. Failure to report fraud. Conflict of interest violations. Negligent verification. Weak documentation. Management collusion. Improper independence disclosures. These create major liability exposure. Now let us discuss a practical case study style illustration. Imagine a listed infrastructure company showing inflated profits for years through manipulated project revenue recognition. Auditors repeatedly ignore inconsistencies despite internal warnings and abnormal accounting patterns. Eventually, fraud surfaces publicly. Stock prices collapse, banks suffer losses. Regulators investigate whether auditors knowingly failed in statutory responsibilities. Now, Section 147 exposure becomes central. This demonstrates the immense practical significance of this provision. Now, let us discuss another governance scenario. Suppose audit firms secretly provide prohibited advisory services while acting as statutory auditors. Later, accounting irregularities emerge involving those same operational areas. Regulators may question whether independence violations contributed to audit failure. Again, Section 147 implications become highly relevant. Now let us discuss the role of company secretaries. Company secretaries play important compliance coordination role, ensuring proper auditor appointment, governance documentation, ROC filings and regulatory compliance systems remain operational. Strong compliance culture reduces audit litigation risk significantly. Now let us discuss the role of chartered accountants. For auditors, Section 147 represents one of the most important professional accountability provisions in Indian corporate law. Professional skepticism, ethical independence, and documentation discipline become critically important. Now let us discuss advocates and litigation implications. Section 147 issues frequently arise in shareholder litigation, fraud investigations, securities proceedings, insolvency matters, and regulatory enforcement actions. Audit working papers often become highly sensitive evidentiary material. Now let us discuss the role of the National Financial Reporting Authority. NFRA dramatically strengthened enforcement environment relating to audit quality and professional misconduct. Modern audit governance operates under far greater scrutiny than earlier decades. Now let us discuss SEBI relevance. Listed entities facing accounting controversies often trigger parallel securities law implications involving disclosure violations, market misconduct, and investor protection concerns. Audit failures therefore frequently intersect with SEBI regulatory scrutiny. Now let us discuss hidden practical concepts. Not every audit error automatically becomes fraud. This distinction is extremely important. Professional judgment errors, technical interpretation differences, and inadvertent oversight situations may differ legally from intentional collusion or willful misconduct. However, repeated negligence or reckless disregard can still create severe consequences. Now let us discuss another hidden concept. Documentation quality becomes critically important during investigations. If audit working papers fail to demonstrate adequate professional skepticism and verification procedures, exposure increases significantly. Now let us discuss hidden exam traps. Students frequently confuse professional misconduct under Chartered Accountants Regulatory Framework with statutory penalties under Section 147. Another common mistake involves assuming only auditors face liability. Companies and officers in default may also face consequences depending upon circumstances. Now let us discuss applicability across company categories. Private companies may involve smaller scale exposure, but statutory principles still apply. Public companies and listed entities create far greater systemic risk due to public investor involvement. Consequently, enforcement intensity often becomes higher in listed company matters. Now let us discuss due diligence perspectives. Investors and acquirers increasingly examine historical audit controversies carefully. Repeated governance failures involving auditors may severely damage valuation confidence and reputation. Now let us discuss secretarial audit perspectives. Audit governance compliance, independence frameworks, and reporting systems form important governance review areas. Weak systems increase litigation and enforcement exposure significantly. Now let us discuss technological transformation. Modern audits involve complex ERP systems, AI analytics, forensic tools, and digital financial records. Yet, despite technological advancement, fraud risks remain deeply connected with human ethics, governance culture, and professional skepticism. Now let us discuss judicial philosophy. Courts and regulators increasingly expect auditors to function as active guardians of financial integrity rather than passive signatories relying blindly on management representations. Substance over form dominates modern governance interpretation. Now let us discuss investor psychology. Investors trust markets only when they believe auditors remain accountable for professional failures. Weak enforcement damages market confidence rapidly. Section 147 therefore indirectly protects capital market credibility itself. Now let us discuss one of the deepest governance insights connected with Section 147. Corporate governance collapses not merely because fraudsters exist, but because gatekeepers sometimes fail to act independently, courageously, and professionally when warning signs emerge. Section 147 exists to ensure that audit responsibility carries real consequences. Now let us discuss broader governance significance. This provision strengthens deterrence, improves professional accountability, supports investor protection, enhances audit quality, reinforces governance discipline, protects market integrity, and ensures that audit compliance remains enforceable rather than symbolic. Now let us discuss practical drafting precautions. Maintain robust audit documentation, escalate fraud indicators properly, preserve independence rigorously, avoid prohibited relationships, conduct detailed verification procedures, coordinate governance communication carefully, document management representations critically. These precautions significantly reduce professional exposure. Now let us discuss why this provision matters profoundly. Because it transforms audit governance into enforceable accountability. It protects investors against negligent and fraudulent audit conduct. It strengthens confidence in financial reporting. It reinforces auditor independence. It improves professional discipline. It supports market integrity. And it reminds auditors, companies, and directors that financial transparency is not optional. Violations affecting investor trust and governance credibility may attract serious civil, regulatory, and criminal consequences under corporate law. For directors, Section 147 reinforces responsibility toward genuine governance compliance. For company secretaries, it highlights importance of procedural discipline and regulatory coordination. For auditors, it represents one of the strongest accountability frameworks governing professional conduct. For investors, it strengthens confidence that audit misconduct will not remain unchecked. For regulators, it supports enforcement of market integrity and financial transparency. For litigators, it creates major liability and evidentiary implications. For students of corporate law, it demonstrates how enforcement provisions shape real governance behavior. And for modern corporate India, Section 147 stands as one of the most powerful safeguards ensuring that auditors remain accountable guardians of financial truth rather than careless or compromised participants in corporate misconduct. Because once audit accountability disappears, investor trust, market confidence, and corporate transparency may collapse together. If you like this video, kindly like, subscribe, and hit the bell icon for latest notifications from Corporate and Securities Law Compass. Like, share, comment, subscribe. Disclaimer: viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India, ICSI, and any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information, UPSI, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.